If you have dual citizenship, or even suspect that you might, the changes coming in February 2026 could quietly reshape your rights, your travel, and your future in ways most people won't notice until it's too late. The US government is preparing major changes to how it handles dual citizenship. These won't dominate the news like elections do, but the consequences are very real. Fines, tougher questioning at airports, stricter tax enforcement, and new complications that can affect your family, your career, and your freedom of movement. The most dangerous part is that none of this will look dramatic at first glance. On paper, it sounds like routine administrative updates. In practice, it's the rollout of a system that tracks, cross-checks, and flags patterns of behavior that millions of dual citizens have followed for years without any issue. If you miss a deadline, fail to disclose something you didn't realize was important, or keep assuming the old rules still apply, the penalties won't start with a warning. They'll show up after the fact. By the time many people realize they're caught up in these changes, the chance to fix things will already be shrinking. That's exactly why you need to understand what's happening before February 2026 arrives. These new rules are not limited to a small circle of people in government or intelligence. They reach into the everyday lives of ordinary dual citizens, people born with two passports, people who naturalized as U.S. citizens but kept their original nationality, couples in cross-border marriages, parents whose children were born abroad, frequent international travelers, retirees who split their time between countries, green card holders getting ready to apply for citizenship. If you've ever told yourself, "I'm legal, I've done everything right, this doesn't concern me," this update is aimed directly at you, because the changes are not about whether dual citizenship is legal, it still is. They're about how visible you are to the system, what you have to report, and how those reports are enforced at a level of coordination the U.S. has never used before for dual nationals. February 2026 marks a transition from a mostly trust-based approach to a centralized, documented one. Things that used to be optional, unofficial, or rarely checked are becoming mandatory, deadline-driven, and linked across multiple agencies. In the next few minutes, I'm going to explain exactly what's changing, who is most exposed, and where people are most likely to be caught off guard. Some changes come with hard cutoff dates. Others may seem invisible at first, but will show up later when you apply for a passport. Try to sponsor a family member, renew a security clearance, or even when you return from overseas travel. Most dual citizens who understand and follow the rules will be fine. But for those who don't, the cost of ignorance is much higher than they realize. Before talking about the new rules, it's important to understand how the U.S. has treated dual citizenship up to now, and why that approach is tightening in specific, targeted ways. Hi, I'm Sophia, and I cover U.S. immigration and citizenship developments, so people can prepare before policy changes turn into personal crises. Let me be clear from the start. This is not speculation, and it's not rumor-driven panic. The February 2026 changes are real policy shifts that are already in the implementation pipeline. I'm not here to scare you, I'm here to give you clarity. Clarity is what protects you. Once you understand how the rules work, you can stay compliant, avoid unnecessary stress, and make smart decisions for yourself and your family. And if dual citizenship is any part of your life now, or might be in the future, this is not something you can afford to ignore. First, we need to clear up a very common misunderstanding. The United States does recognize dual citizenship. You can legally be both a U.S. citizen and a citizen of another country at the same time. Unlike certain countries that force you to formally renounce your previous nationality when you naturalize, the U.S. has historically taken a relatively permissive, low-interference stance. But permissive has never meant passive. From the U.S. government's perspective, when you are in the United States, you are treated as an American citizen first. Regardless of what other passport you hold, you are required to enter and exit the U.S. using a U.S. passport. You are subject to U.S. law, and crucially, you are required to report and pay U.S. taxes on your worldwide income, even if you live overseas or earn money entirely in another country. For many years, this system leaned heavily on self-reporting and limited sharing of data between agencies. Unless you applied for a high-level security clearance, worked in a particularly sensitive government or defense role, or triggered a tax investigation, your dual citizenship often sat in the background. Many people live their lives without ever being formally asked to declare or register that second nationality. That quiet, informal status is what's ending. February 2026 does not outlaw dual citizenship, but it ends the era in which it was largely unspoken and untracked. The government is moving toward a model where dual citizenship is explicitly documented, monitored, and cross-referenced across immigration systems, border control, tax enforcement, and national security databases. That matters because actions that used to be effectively invisible to the system are about to become highly visible. Your travel patterns, your foreign bank accounts, any foreign military service, political activity in another country, even your children's possible citizenships. All of these separate elements are about to be linked in ways they never were before. This is why so many people will be blindsided, not because they violated the law, but because they didn't realize that the rules about what must be disclosed had fundamentally changed. Once you understand this foundation, the rest of the new requirements fall into place. Dual citizenship remains legal, but now comes with clearly defined obligations and deadlines that did not previously exist. Now we move from theory to concrete changes. The biggest single shift in February 2026 is the creation of a mandatory registration system for dual citizens. For the first time in U.S. history, every U.S. citizen who also holds another citizenship will be legally required to register that status with the federal government through a new online system operated by the Department of Homeland Security. Up to this point, there has been no universal legal requirement to formally notify the government that you have another citizenship. That gap is closing. Beginning February 1st, 2026, a 6-month countdown begins. You will have until August 1st, 2026 to complete this registration. This applies whether you were born a dual citizen, gained citizenship through marriage, or became a U.S. citizen by naturalization while keeping your original nationality. The registration will demand details many people have never had to provide before: which countries you are a citizen of, passport numbers from those countries, any past employment with a foreign government, and any service in a foreign military. Failing to register won't be treated as a minor technical slip. It can lead to fines up to $5,000, complications with renewing your U.S. passport, slower or more intensive security screening, and potential problems when you sponsor family or deal with other immigration processes in the future. What makes this especially significant is that this registry is not being built as a standalone database. It is designed to connect to other government systems. Border agents, immigration adjudicators, and compliance teams will all be able to see whether you've registered and whether what you reported matches your travel records, tax filings, and earlier disclosures. This is not something you can safely ignore or get to later. Missing the deadline doesn't just create an extra form to fill out, it creates an official compliance issue attached to your name. If this applies to you, this is the time to mentally circle those dates. Waiting until the final days is risky if the system gets clogged, if there are technical glitches, or if you realize you're missing key documents. For those in especially sensitive fields, the new rules go further. If you're a dual citizen working for the federal government, a defense contractor, an intelligence or national security agency, or in critical infrastructure positions, February 2026 brings tougher reporting obligations and more scrutiny. Under the updated framework, you may have to disclose not only your own dual citizenship status, but also the citizenships of your close family, parents, siblings, spouse, and children. Foreign financial connections, bank accounts, real estate, or business stakes will be examined more closely. Even routine contacts with officials from your other country of citizenship might need to be reported, depending on the nature of your job. Many professionals are worried not because they have done anything wrong, but because they understand this can directly affect careers. Extra layers of review during security clearance updates can delay approvals, restrict what you're allowed to access, or even lead to reassignment away from certain roles. Some agencies may, quietly and unofficially, limit promotions or assignments for dual citizens in the most sensitive areas. This doesn't mean dual citizens are being shut out of government and security-related work, but it does mean that being transparent is no longer optional. If you're in one of these sectors, you should talk to your security officer or HR department before the rules kick in. Waiting until you're questioned puts you on the defensive. In high-stakes professional environments, being ahead of the curve matters. Travel is another area where dual citizens will feel the impact quickly. Starting in February 2026, U.S. Customs and Border Protection will implement enhanced screening for dual citizens, particularly those who move frequently between the United States and their other country of citizenship. This does not mean your travel rights vanish, or that your dual nationality is suddenly suspicious by default. What changes is how much the system sees and how it uses that information. Border officers will be able to look directly at the dual citizenship registry alongside data from U.S. and foreign passports. If the system detects extended stays outside the U.S., especially more than 6 months in a year, and especially if those stays are mainly in your other country of citizenship, you may be pulled into additional questioning at the border. Officers may not be aggressive, but they will want details: where you actually live most of the time, where you work, where your immediate family is based, and how solid your ties to the U.S. really are. While simply traveling doesn't endanger your U.S. citizenship, patterns of long absences can matter in other settings. If later you try to sponsor relatives, seek specific government benefits, or interact with immigration authorities for family members, a history of living largely abroad can raise red flags. Officials are increasingly interested in whether someone is a U.S. citizen in practice or mainly on paper. If you're a dual citizen who travels a lot, your best defense is to be organized. Keep strong documentation of your U.S. residence, your job or business here, your tax filings, your U.S. bank and investment accounts, and your community connections. File your U.S. taxes correctly. Keep key records where you can access them quickly. If questions come up at the border, being ready with a clear, calm explanation, backed by facts, can make a big difference. The aim of these policies is not to punish people for traveling, but to measure consistency in how your life is actually anchored. The area where the government is becoming noticeably less forgiving is taxes. The legal framework itself hasn't changed. U.S. citizens have always been obligated to report and pay tax on worldwide income, no matter where they live or what other citizenships they hold. What is changing in 2026 is how aggressively that is enforced. The Treasury Department is expanding agreements with foreign banks and tax agencies, giving the IRS much more visibility into foreign-held accounts, investments, and properties owned by U.S. citizens. If you're a dual national with money, property, or investments abroad, you should assume those ties will no longer be hidden. One recurring source of trouble is the requirement to report foreign bank and financial accounts. If at any point in a year the combined value of your foreign accounts goes above $10,000, even briefly, you are required to file an FBAR, which is separate from your regular tax return. Failing to file can lead to penalties up to $10,000 per year per violation. In serious cases, where the IRS believes you willfully chose not to report, penalties can go as high as 50% of the account balance or $100,000, whichever is more. In 2026, the new dual citizenship registry will be directly cross-checked against tax returns and FBAR filings. If you report that you are a dual citizen of a certain country but have never reported any foreign accounts or income from that country, your file is much more likely to be flagged for closer review. That's why getting into compliance now, before that system is fully live, is so important. If you're not sure whether you've done everything correctly, this is the time to speak with a tax professional who understands international issues. Review previous returns, identify possible mistakes, and use voluntary compliance programs where appropriate. Hoping the gaps stay unnoticed is becoming a very weak strategy in the new environment. There is another change that could have serious consequences for some dual citizens: foreign military service. This is particularly relevant for those whose other country of citizenship has compulsory or strongly expected military service. Under U.S. law, serving in a foreign military has always carried risks for your citizenship, but in the past, the government usually needed clear proof that you intended to give up your U.S. citizenship. That requirement for proving intent is shifting. From February 2026 onward, if a dual citizen voluntarily joins a foreign military, especially in a combat role or as an officer, the default assumption may tilt against them. Instead of the government having to show that you meant to relinquish your U.S. citizenship, you may be put in the position of having to show that you did not. That's a subtle legal shift, but a very powerful one. There are still protections. Truly compulsory service, where you had no realistic alternative, and non-combat roles in the armed forces of close allies are treated differently. But the gray zones are where people are most vulnerable. Even short stints of service, accepting rank, or taking an oath to a foreign commander can be used in future evaluations of your status. Starting in 2026, any prior foreign military service must be declared when you register your dual citizenship. That information can influence decisions about security clearances, eligibility for certain government jobs, and immigration outcomes in some family-related cases. If you are thinking about serving in a foreign military, or if you already have and never fully considered the consequences, this is not something to guess your way through. Getting qualified legal advice before taking action can be the difference between keeping your status secure and facing problems that are very hard to undo. All of this connects to another shift: how the U.S. handles dual citizenship for people becoming citizens through naturalization. If you're a permanent resident planning to apply for U.S. citizenship, February 2026 brings more explicit explanations and formal recognition of what it means to keep your original nationality. The Oath of Allegiance has always included language about renouncing prior allegiances, but in practice, the U.S. rarely forces new citizens to actually give up their other citizenship. That continues to be the case. What's new is how clearly post-2026 naturalization ceremonies will spell out your ongoing obligations as a dual citizen. These will include the requirement to register your other citizenship, your tax responsibilities, and the rules around using passports and traveling. Newly naturalized citizens who keep another citizenship will have to acknowledge in writing that they understand these obligations, and they will be told they must register their dual citizenship within 30 days. This matters because many people assume that once they become U.S. citizens, their old citizenship issues vanish automatically. In reality, whether you keep or lose that other nationality depends on the laws of the other country, not the U.S. Some countries automatically cancel your citizenship when you naturalize somewhere else. Others happily allow dual citizenship. For example, China and India generally do not allow dual citizenship. Becoming a U.S. citizen often means losing citizenship in those countries under their own rules. In contrast, Canada, the UK, France, Mexico, and many others fully allow dual citizenship. From 2026 onward, new citizens will have these distinctions explained to them more clearly, and will have to confirm that they understand what applies in their case. That means there will be far less room later to say, "I didn't know," if they fail to meet registration or tax duties. If you plan to naturalize, it's wise to understand how both U.S. rules and your other country's rules intersect before you take the oath. Political activity in another country is also coming under closer review. Under U.S. law, dual citizens are generally allowed to vote in foreign elections, support parties, and campaign in their other country. That basic permission is not going away. The shift is in how carefully the U.S. looks at more formal forms of political involvement, especially when you hold some type of official role. From 2026, dual citizens who run for or accept official positions in foreign governments will see more attention from the U.S. side. This includes serving in a foreign parliament, becoming a minister or senior official, or working in roles that look or function like diplomatic positions. The central concern is intent. Swearing an oath of office or pledging allegiance to a foreign state can be interpreted as evidence that you intend to give up your U.S. citizenship, even if that's not what you personally believe. Historically, only extreme cases came under serious review. Under the new system, the monitoring will be more systematic and less casual. For everyday life, little changes. Voting abroad or joining political discussions is fine, but if you see yourself in foreign public office or are offered a government position in another country you're a citizen of, this is an area where professional legal guidance is essential. The law leaves room for interpretation, and how your choices are seen will depend heavily on underlying facts, documents, and behavior over time. The point is not that foreign political roles are forbidden, but that they can create citizenship questions that never used to surface. Families with dual citizen children will also feel these changes. Many parents don't realize that a child born outside the U.S. to American parents may automatically be both a U.S. citizen and a citizen of the country of birth. From February 2026, when parents apply for a consular report of birth abroad or a U.S. passport for such a child, they will have to state whether the child has or could have another nationality. That data will go into the dual citizenship registry just like it does for adults. Parents will be responsible for registering and keeping their children's dual citizenship records accurate, including updating them when circumstances change. For globally mobile families or those strongly tied to more than one country, this adds a new layer of administration. It also shapes the child's future. The government has already signaled that this tracking will matter later for security clearances, for tax obligations once the child becomes an adult, and for clarity when that child applies for their own passports, visas, or government jobs. While this is more work for parents now, it can reduce confusion and conflict later by creating a clear citizenship paper trail from the beginning. Parents need to understand these duties, especially since young children cannot manage them on their own. Another area where many people will be surprised is in family-based immigration. Starting in 2026, if you are a dual citizen sponsoring a spouse, parent, child, or sibling for U.S. permanent residence or an immigrant visa, your own dual citizenship will be looked at more closely. Officers will examine where you actually live, how often you travel, where you pay taxes, and whether you truly keep your primary home and life in the United States. The concern is about so-called paper citizens, people who have U.S. citizenship on paper but live almost entirely abroad, only interacting with the U.S. system when they want to bring relatives in. Dual citizens are not being blocked from sponsoring family, but you may be asked for stronger proof of U.S. domicile, intent to live in the U.S. with the sponsored relative, and sufficient financial support from a genuinely U.S.-based life. If you're a dual citizen living overseas and plan to sponsor family, you'll need to plan further ahead. Collecting evidence of U.S. ties before filing can prevent delays, additional evidence requests, or unexpected denials. One important point that often gets lost. While the government is raising compliance demands, it is also making the process slightly clearer for those who decide they no longer want dual citizenship at all. Beginning in February 2026, the State Department is updating its rules around renouncing U.S. citizenship. The goal isn't to push people to give it up, but to make sure anyone considering it truly understands the seriousness of that choice. If you decide to renounce U.S. citizenship, you will still need to go to a U.S. embassy or consulate abroad, swear a formal oath of renunciation, and pay a substantial fee. What's new is a required pre-renunciation counseling step. Before they schedule your appointment, you'll receive detailed information about what you are giving up. The right to live and work in the U.S., potential difficulties entering the U.S. later even as a visitor, and serious tax consequences, including possible exit tax on your worldwide assets if you meet certain criteria. This extra step is designed to prevent people from making a permanent decision in anger or confusion over new rules. Once you renounce, getting U.S. citizenship back is extremely rare. On the flip side, some dual citizens may decide it's better to give up their foreign citizenship instead. Many countries make this possible, but the process can vary a lot. Some require lengthy paperwork and proof of another citizenship, while others are relatively simple. Starting in 2026, the new registry is expected to include general information on renunciation procedures for different countries, helping people understand what's involved. For most dual citizens, giving up either citizenship is unnecessary and unwise. Dual citizenship still offers real benefits: mobility, options, and connections. But for those in the most sensitive government roles or those who feel overwhelmed by the obligations, choosing one citizenship may feel more comfortable. The key is that such decisions should be informed and deliberate, not rushed or based on misunderstandings. With all of this in mind, what does good preparation actually look like? The most effective move you can make right now is to be fully aware of the timeline. Mark August 1, 2026, the registration deadline, and treat it as non-negotiable. Don't wait until the final days. That's when systems crash, documents go missing, and avoidable mistakes happen. Start gathering what you'll need now: all passports, naturalization and birth certificates, and documents for immediate family who may also have dual citizenship. If you have children born abroad, make sure their paperwork is complete and correct. If you have foreign bank accounts, investments, or property, Review your tax history and find out if you should have been doing additional reporting. If you're unsure, seeing a tax advisor with cross-border experience is not overreacting. It's smart prevention. If you work in areas that rely on security clearances, government contracts, or critical infrastructure, contact your security or HR office now, before February 2026. Being open early usually protects your career. Staying quiet and then being discovered by the system can damage trust. If you travel often, start keeping a clearer record of your U.S. ties, lease or mortgage, employment documents, tax statements, bank records, utility bills, and proof of community participation. These things might feel routine now, but they can become crucial evidence if questions arise. And finally, staying informed will be more important than ever. Many implementation details are still being finalized, and agencies will continue to release new guidance. Checking official government sources, following reliable immigration and policy coverage, and talking with other dual citizens can keep you ahead of the curve instead of scrambling to catch up. These policies are not meant to target ordinary people with legitimate cross-border lives, but to bring more visibility and consistency to a world where global movement is increasingly normal. If you prepare and document properly, dual citizenship remains not just lawful but valuable. There are also recurring worries that deserve straightforward answers so that misinformation doesn't create unnecessary fear. First, the U.S. is not abolishing dual citizenship. It remains recognized and legal after February 2026. The focus is on registration and enforcement, not on banning the status. Second, the U.S. government cannot force you to give up another country's citizenship. It can, however, impose obligations that make being a dual citizen more structured and transparent. Rare but serious actions like volunteering for another country's military or swearing official allegiance to a foreign government can be interpreted as giving up U.S. citizenship, but that has long been part of existing law. What's changed is how closely such situations are monitored. People also worry, what if I didn't even realize I had another citizenship? That is a real scenario. Some individuals automatically acquire foreign citizenship from parents or grandparents without ever requesting a passport. If you discover this, authorities are generally more lenient when you step forward and register promptly than when it appears you tried to hide it. Finally, many fear that travel itself will be heavily restricted. That is not what these changes do. You can still travel as a U.S. citizen. If your travel pattern raises flags, the difference between a routine question and a stressful ordeal is usually your preparation, having documentation and reasonable explanations ready.